Ulrich Roux, the criminal law attorney who's joining us live now. Ulrich, thank you so much for your time. I mean, you think about all these arguments that were presented in court, and quite a lot of it sounding, urgent on both parts. You hear the defense saying that for us this matter is urgent because we do not understand why our client has to be prejudiced in this manner. Her rights have been infringed upon. That's according to the defense. And then you hear the state saying that rule on this matter as urgently as possible because this for us is a non-starter, because we've done everything by the book, even presenting some of the dates that they say that they have been engaging with the legal teams on. But when you look at this particular moment and the fact that there's now this apparent negotiation on whether or not to arrest and when to arrest or what is going on here, how unprecedented is this moment?
Yes, well, it's not unprecedented in its entirety. We have also launched interdict applications before where we interdict the NPA or the police from effecting an arrest against the client. In this instance, I must say, however, that some of the relief sought by the Speaker's legal representatives, I do not think they can achieve. For instance, where they have requested the court to grant them access to the police docket prior to the investigation being completed and prior to disclosure being made correctly during the course of the criminal proceedings that will be leveled against her. But certainly if they can prove that, there's substantial reasons as to why she should not be arrested, then it is not that unprecedented. In this instance, I must say that I agree with the arguments made by the NPA. The mere fact that an attorney is not available when a person should appear in the commercial criminal crimes court is not sufficient reason for such an arrest to take place. But we would have to wait and see now whether the judge agrees with that argument or not. It has, however, all become somewhat academic because the judge has reserved her judgment until next week, Tuesday, which is the 2nd of April, and the Speaker has indicated that she's more than happy to hand herself over to the police on the 3rd of April. So she will not be arrested until then. So I do think that the entire application has become somewhat moot at this stage.
Yeah, and Ulrich, I wonder then, when it comes to this issue of the furnishing of the docket, because it became, quite of the most focus, even last week as well, when one was going through her papers. Is this something that is done in the courts?
No, so we have what we call the Audi Alteram Partem rule, which confirms that both sides must always be heard during a legal argument. But also we have the Access to Information Act and a case that was decided upon in 1994, and it is well known as the Shabalala case, where an accused person does have the right to have access to the police docket, which contains all of the information and the evidence that the state intends on using when they do prosecute the matter. But the content of the docket can only be handed over to the defense once the investigation has been completed in its entirety and the NPA has confirmed that the matter is trial ready and accordingly a trial date can be set. Only at that stage can they have access to the docket in order to determine what the veracity of the evidence is against them, and in order to either prepare their defense or to issue representations on behalf of their client in which they point out to the National Prosecuting Authority that the case is completely flawed and that there is not a reasonable prospect of a successful prosecution in the matter. At this stage, it is certainly very premature to demand that a copy of the police docket be handed over to the Speaker and her legal representatives. And the judge was quite correct in her findings that she cannot enter into the arena and fill the shoes of the NPA to decide when the docket must be handed over to the defense and to the Speaker in this instance. So it's unprecedented that she would get a copy of the docket now, and certainly I don't foresee that any court would make a ruling that she is entitled to the content of the docket at this stage.
It's going to be an interesting one. Ulrich, thank you so much for your insights this afternoon.